let the matter be listed accordingly after 3 weeks, enabling the Standing Council Education Department to file his affidavit in opposition, if any, after obtaining the wherever instructions from the department concerned.
Deeply obliged.
My lord. My lord, may I mention item number 5, my lord?
Item number,
Item number 5, my lord. I have
Five.
taken, yes, my lord. I have taken consent from the respondent, my lord. And affidavit is still not filed, my lord. So, my
you
lord,
are for the petitioner here, or?
yes, my lord. My lord, I may be allowed to,
Huh?
my lord, take adjournment, my lord, for
Oh, why
two,
you need
2 weeks, my
adjournment?
lord. My lord, there is still affidavit has to be filed, my lord.
Still affidavit by the respondent side or by
Yeah,
you?
respondent, my lord.
It is the respondent. You are for the other side. Comment.
Respondent number 1.
Okay, then the consent of the other side, learned counsel. You are for the petition.
Yes, my lord.
Require an adjournment. Where allowed, list accordingly. After 2 weeks, we'll do
Okay, my lord.
list after 2 weeks.
My lord, in regard of item number, my lord, 7, my lord. I also want to, my lord,
Since item number 7, what is the problem?
my lord, I have taken consent from the respondent, my lord.
Huh?
I have taken say, my lord, affidavit is not, building is not ready, my lord. So,
That is their actually concern. They have not filed affidavit or whatever. It's their concern, in fact.
my lord,
Why
so-
you are seeking adjournment in that?
yes, my lord.
7. Here also you are appearing in item number 7. Item number 7, you are appearing. The number here. And for C and for 2 and 3 also.
No. My lord, this is eviction with my affidavit will not be required. my lord. Yes.
Also, we have received extra copies, petition copies just in February only. So, lots of will take time to file affidavit. Another 4 weeks time.
Odugong, my lord. My lord, there is something more than, they may continue. Into more than. Obliged.
My lord, I would to mention item number 3 and 19 on behalf of N. Taje for adjournment. 19. No, not present because he is out of station now. Suddenly his brother had expired last night, so that he had gone to village. So matter may be fixed after 3 weeks. And I have also taken consent from the other party. Come.
I mean, item number 19, Your Lordship. 19, only 19, not 3.
Yes,
Yes, 19 only. Health.
health. I have taken consent from him. Oh, yes. Much obliged.
Lordship, I would like to mention item number 21, Your Lordship. Here we have to file affidavit, Your Lordship. 3 weeks may be granted, Your Lordship. Yes, Your Lordship. Yes, Your Lordship.
For the petition.
Arbasar, Your Lordship.
Government advocate wait for an adjournment, stating that how many weeks you need?
3 weeks, Your Lordship.
3 weeks will be required to file her affidavit in opposition. Prayer allowed, list accordingly, list the matter accordingly after 3 weeks.
Apply, Your Lordship.
My lord, I beg to mention item number 13. So I need some more time for filing rejoinder, my lord.
You want to file rejoinder?
Rejoinder, yes.
Otherwise, the opposite, the respondent side has already filed their affidavit in opposition. You have filed.
Yes, I have filed, my lord, I have filed. My opposition.
So you are for the private
I
respondent?
am private respondent 4.
Private respondent 4.
Yes, I have received all the opposition. Affidavit in opposition I have received from all the respondents.
So all the
Yes,
respondents have already filed.
Yes, yes. Just I need some time, my lord, for filing rejoinder.
Your good name?
Udeka.
Or Udeka? Heard Mr. Udeka, the Learned Counsel for the petition, and also heard Mr. You are for respondent number?
1, 2, 3.
On number 1, 2, 3. Is it department?
Yes, study. RD.
RD,
Yes.
Standing Counsel RD, and also heard MS Arbas, the learned government advocate, appearing on behalf of your appearing. Oh, you are appearing.
Number 8, Your Lordship.
Iwango appearing on behalf of respondent number 8. 8, government advocate. And also heard Mr. You are Mr.
Private respondent number 4.
You are
Tika Kama, yes.
Tika, my lord, private respondent number 4. It is submitted by Mr. Deka that all the defendants have already filed their affidavit in opposition, but he needs some more time to file his written affidavit in reply. Is how many weeks you need then?
2 weeks, my lord.
2 weeks. This the matter accordingly after 2 weeks, enabling the petitioner to file their affidavit in reply.
Okay.
I beg to mention item number 1 on behalf of Mr. Elbam petitioner.
Item number 1,
Yes, Your Lordship.
on behalf of
Mr. Elbam for the petitioner.
help or me,
Elbam.
Yes,
Your Lordship. This matter may kindly
Mr.
be.
Parmi is also there.
He's also absent today.
Mr. Parmi, the government council.
I've taken
consent.
Yes, yes, Your Lordship.
Your good name?
J. Koyu.
Heard Mr. J. Koyo, the learned counsel for the petition, appearing on behalf of Mr. Album, the learned and his counsel, and also heard Mr. Irene, the learned government advocate for the state respondent. It It is submitted by Mr. Swenso that due to some personal inconvenience, Mr. Bam court today, and accordingly, the government advocate, Mr. List accordingly, how many weeks you need?
2 weeks.
2 weeks. List after 2 weeks.
Your Lordship, there is an interim that may be continued.
Interim be continued to next date of listing.
Obliged.
My Lordship, I beg to mention item number 10, Lordship. Lordship, I am for the petitioner here. Lordship, I want to file my affidavit in
It was
reply.
fixed, in fact, the matter was fixed, in fact.
Yes, Lordship, I want to file Lordship affidavit in reply, Lordship. Lordship, the matter may be fixed for next week, Lordship, of this 20, Lordship. 20th of this, 20th of June, Lordship, next week.
So again, you want to fix it. In that
Yeah.
case, you honor before 28th, you'll just file your,
Yes, before that, I will
Affidavit.
file my affidavit in reply. And Lordship, till then, Lordship, on 20th, Lordship, we will try to dispose the matter, Lordship.
with the consent of the other side, Mr. G. Jinin, the counsel for the petitioner, pre-turn adjournments, stating that he could not file his affidavit in reply, and accordingly paid to list the matter on 26/2024, stating that on or before the next date of listing, he will file his affidavit in reply. List the matter accordingly on
20th, Lordship, we have fixed matter.
26. 20 is a key day,
Thursday, Lordship.
Thursday.
Much appreciated.
Item number 29.
Please, my lord.
Hmm.
My lord, here I am challenging the impugned order dated 24/5/2024. The State Commission remand back the second appeal to the
Appeal.
first appeal.
Hmm.
That was the case. So now basically questions comes up whether the State Commission can remand back the matter to the first appellate authority. That is the larger questions. The now fact of the matter is that, my lord, I have filed RTI applications on 23/6/2023. POI has not supplied that required copy. Then I moved to the first appellate authority on 14/8/2023. Then also, then this PIO, this first appellate authority is marked to the PIO for the supply of the information. Then accordingly, I 9/2020, partially I have received the information, so not fully. Then I again, then this application has been not disposed of by the first appellate authority. Then I then appeal before the second State Commission under Form EE. Then second, then they take cognizance and issue notice to the parties, and after hearing the parties, then they remand back the matter to the State Commission, the first authority, appellate authority, to pass revision orders, which is against the article section 19 of the RTI Act, 19 clause 3 of the RTI Act. The Act never says for the
We
remand back of.
have submitted that the first appellate authority did not dispose of the matter, in fact. So that may be. the
Pardon,
reason.
ma'am?
The first appellate authority did not dispose of the matter with any reason.
Yes.
Only he asked the RTI officer to provide you the copy.
Correct, my lord.
Now the question is that for that reason, maybe the second appellate authority has remand back.
No, this first appellate authority that section 19(1) says whether it may dispose of not. After lapse of 30 days, limitation period is over, then you can go to the second appeal. That is the question, legal issue here.
So now.
So-
you are-
so
you are
now-
against the order of 24/5/2024.
Yeah, then 24/5, this is remanding back to the matter to the first appellate authority, which is illegal as per the 19 clause 3. So,
You have annexed the order?
then this first appellate authority issue me this notice for appearance on page 6, which is per se legally not tenable, my lord. So therefore, I request this honorable court to stay this notice and this notice for appearance as well as for the that remand back order of 2024, 24/5/2024.
Yes.
My lord, I'm appearing for respondent 3 and 4. I don't know, my lord, there's information coming. Has also standing counsel. I don't know whether this, it sees this section 19 of the Information Act. Right to
IT.
information.
Put it on.
Their exits are not available. There? हाँ? देख लो ना ये सब लगना चाहिए.
No,
Required books, ना?
Lordship say
Yes.
19 subclause,
3.
no, 3, of course, my lord, within shall lie, this is, my lord, within which period the appeal shall lie, that's the given entry, my lord. Like Lordship sees 10, my lord, subsection 10. So there's no bar, my lord. It says the Central Information Commission or State Information Commission, as the case may be, shall decide the appeal in accordance with such procedure as may be prescribed. That's the only thing, my lord. Where is the bar, my lord? No, my lord. What is the, my lord, defect in the order, my lord? The commission says because first appellate order is not passed an order in a reason order, my lord. Let the first appellate to pass a reason order by speaking order. Then if they are agreed, they can come to the state commission again, my lord. They have not been barred. If now, lordship, they have annexed, themselves have annexed page 38, lordship. This is the full bench, decided by the commission, my lord.
30.
30, it starts from 37, man. This is a resolution passed by the State Information Commission, madam. 5 members are there, madam, including the Chief Information Commission. Lordship will see page 39, madam. Signed by 5 information commissions. This is the resolution. Now, if your lordship kindly turn to page 38. If my first, second, third, fourth paragraph, lordship, as laid down at para 38, lordship got it.
Yes.
Guidelines for FAA means First Appellate Authority, man. Issued by the government of the state government, adjudication or appeal under RTI as a quasi-judicial function. It is therefore necessary that this specific information, but 6 indiscriminate, vague information like information to multiple numbers of years and multiple numbers of schemes. What this says is, first of all, the first appellate authority should pass a speaking order, reason order, giving chance to both of the parties. As the first appellate authority has not done in this case, this information commission has remanded back. What's wrong in that one? It's not that their rights have been totally snatched away by the commission. Date is fixed tomorrow, in the first, your lordship is the last page. Page 43, your lordship. Last page.
Yes.
Whereas such and such appear under such and such. against the MD, Campio AP State Cooperative Pacific Limited, Nahalagan for refusing to furnish all information or appointment of various officer staffs appointed in Abscal Limited by appeal dated 14/8/2000. Whereas an order by the honorable member of State Information Commission, the said appeal shall be heard by the undersigned first appellate authority on 13/6/2020 at 12 hours in the office chamber administrator Apex Bank, HOD, D sector. Therefore, the appellant and the PO Apex Bank respondent are directed to appear before the undersigned in person on the above mentioned date and time with all the relevant documents, files to plead their cases issues. My lord, it will be heard tomorrow, my lord. Why he wants to delay his matters, my lord, prolong, if this matter is pending, my lord, if this honorable court says, my lord,
What prejudice will cause to you, in fact? Why are you approaching this court? What prejudice will cause to you? Because matter is fixed tomorrow for hearing. You're
Yes,
going to give a chance for hearing.
Milord,
Undoubtedly, there is a provision of second appeal that is okay. That is, a limitation period is there within 90 days or
Yes,
something you have
yes,
to.
yes.
But that doesn't bar the second appellate authority to remand back the matter. Why?
No,
Because it is
Milord,
possessive in nature.
Milord, kindly first, before that, kindly first, their minutes of meeting, they said 5 judge bench. In other than the High Court and Supreme Court, there is no such 5 judge bench in the state commissions. In RTI Act, this never says there is 5 judge bench, there is bench, there is commissions. You see
are against
the,
the minutes also.
yeah, this is only minutes of meeting. Whether now questions comes up, whether this minutes of meeting is override, can override the statutory provisions or not.
No,
That is another questions of fact. Then they refer the-
Meeting itself, it is there in the last thing, what is as Mr. Toko is pointed out, there is a provision, I think.
No, the second appeal 19 clause sub clause 3 is there is no such provisions. Whether state commission has either you decide the matter or you reject it or you pass the appropriate order in favor of me. That is the provision there. Milord, now the learned counsel is saying the judgment laid down in the CBSE matter, that is only appellate authority. It can be the first appellate authority or the second appellate authority. It never says first appellate authority should pass the reason order, speaking order. It never says.
Obviously, every appellate authority has to pass a reason order.
Yes,
It
but
is not
it,
acceptable if it is a reason order is not passed by. Suppose in the civil, other civil matters also, there is a provision, if the first appellate authority has not passed any reason order, that is the right has with the second appellate authority to remand back the case.
no,
So
Milord,
what is the harm?
Milord, what I'm saying, this is a judgment which is specific. Yeah, honest. Para 37 is specifically what sir was pointed out. That was specifically mentioned here. This judgment, which referred by the commission, is only authority. Now, speaking order has to be passed by the second appellate authority, where my application is pending. That my appeal has to be decided by the speaking order.
my lord, this is every
Just,
state.
just, Milord, my application has been lingering by that hand and glove, they are connivance with the authority. They are just lingering. So now again, they will take another time, tomorrow hearing, then again I prepare for the second appeal. It will take much time.
Why you are apprehending that the no favorable order will be passed in favor of you?
No,
Is
no,
there any reason?
no, Milord, I am not
And
saying
you
it.
want to again approach to the second appellate authority, why? If it is satisfactory order has been passed by the first appellate authority, what is the harm?
No, once,
You may satisfy with the order of the first appellate authority. I don't know what order will be passed. That is a different thing. You also don't know. But
No.
why you, the prior
His apprehension, my lord, it will go
why
against,
you-
my
the
lord.
prior apprehension is that
No,
no
no, Milord,
favorable
Milord.
order will be passed.
Milord, my question is, I am not favoring from any authority. So my only question is, section 19 sub clause 3, there is no provisions of remand back to the matter. Otherwise, it will be tomorrow, it will be become a tactics of this PIO authority, public authority.
My lord,
First, second appeal, then again you remand back, you pass here, again come up for second appeal.
my lord,
This will just lingering the systems.
let's
That's
see,
why I come here. That is the only reasons here.
my lord, let's see the section, my lord, my brother is referring to, my lord, that 19(3), my lord. This is totally different thing, my lord. May I read, my lord? 3. A second appeal against the decision under subsection 1 shall lie within 90 days from the date on which the decision should have been made or was actually received with the Central Information Commission or the State Commission, my lord. My lord, it's nothing to do, that it doesn't bar, my lord.
No, before reading this 19 sub clause 3, let us read sub clause 1, sir.
Yes, read.
One says, any person who does not receive a decision within the time specified in subsection 1 or clause A of the subsection 3 of section 7, which is my information, which I was seeking, or is aggrieved by a decision of the central information, which is referring to the center, or the state public information officer, as the case may be, may within 30 days. My lord, these 30 days, I have not received any information. Within 30 days, after expiry of such period, from the receipt of such decision, prepare an appeal to such officer who is senior to the rank to the central information audit. So that proviso said, further says that such officer may admit the appeal after the expiry of the period 30 days, if for receipt. Because here, either he will decide or not, it will not matter. After 30 days, if I decide the first appellate authority, then it's well and good. Whether I satisfy or not, that is against up to me. Liberty has given to me. If you are not satisfied the decision of the first appellate authority, then you can go to the second appellate authority.
Yes, yes, yes.
Then result of this sub clause 1, I have prepared this 19 sub clause 3. Because first appellate authority has not decided my applications. That is the sole reason. They just endorsed to the PIO. PIO then substantially, partially they have provided information. So I was dissatisfied with the decision of the decisions of the first appellate authority. That's why I'm here before the second appellate authority. Then second appellate authority, after admission hearing, after hearing both the parties, then says it is immature. Without deciding my matter, they says it is a 5-judge bench decided the matter by minute of meeting. So I'm asking whether this 5-judge, this commission member, can override the statutory provisions of the RTI Act. It cannot be, my lord.
The question of overriding, it's not here.
Where, that's why I'm saying, where it has violated, my lord, that my brother should point out this provision has been violated, man. This provision doesn't say.
This minute of meeting is violating the
No, we
this
are not
overriding,
minutes of
violating the RTI 19 sub clause 3.
Go by the minutes of meeting, but
Yeah,
otherwise
see-
how it is violated? The question is how it is violated. Now in CPC also there is no specific provision of remand any. They do not remand.
Yes,
So
madam.
the question is that if it is suppose there is grounds for remand the matter, then obviously the authority concerned has the authority right to remand back the matter. So that a genuine or reason order may be passed by the subordinate authority or the concern. So that is the reason why it has been passed.
Section 20 doesn't
Below-
bar, my lord.
No, my lord, before going to section 20. So my only question is, this commission should,
Yeah, then if you want to see, we can dispose of the matter today itself, or if you want, then we will issue notice.
my lord, kindly issue notice and stay there that this
Stay.
kind,
Just appear, you may get a favorable order also. The RTA information you may get also. If you get the RTA information as you sought for, then the matter ends. there.
Yes, ma'am.
Then matter ends there.
then my lord, in that aspect, kindly issue the notice and make an observation that this pendency of this should not affect to that hearing. The pendency of this WPC should be not like the bar to that, affect to that providing information and all. Otherwise, tomorrow that first appellate authority says, you have already gone to the High Court. The matter is pending before, I am not going to provide this information. Let me say so.
They can say that thing.
My lord, this is the on field, this is a problem here. That's why I want to dispose of the matter before the state commissions. So state commission should pass under 19.3, either dispose of, either reject it or ultimately they have to decide the matter.
Well, it has disposed of, my lord. What my brother wants to say, it has, commission has.
Unnecessarily, they're
disposed of the
remanding back to the first appellate authority, past region order. This is,
Remanding back is also disposal of the petition, my lord.
It considers that.
Yes,
Tell us, should I dispose of the matter?
yes,
today?
my lord. It's for.
no, my lord, kindly give notice to the,
It's
it should
better
not
for him also, I don't know, my
It will be
lord.
better for you also. I
Yes,
think. we can dispose of the matter with a direction to the first appellate authority maybe
Yes, my lord.
to pass a reason order
Yes,
as per the so and so.
yes.
In that case, it will
It
be.
won't prejudice any of the parties, my
No,
lord.
nothing at all.
That,
Don't-
that can be, that observation can be made. We give the directions.
No, direction in a sense,
It's
definitely.
tomorrow, already matter is fixed, my lord.
Matter is fixed tomorrow. So you appear before the.
Yes, ma'am.
I mean, the authority, then if suppose the required data you get by the tomorrow's order, suppose,
Yes.
then your matter ends there also.
Yes.
Because your only grievances is some of the information you have already received. But the RTI officer did not, deliver all the information you required. That is the
Correct,
only
correct, my lord.
issue. And the first appellate authority has not passed any reason order.
Yes, ma'am.
While while directing the RTI officer, he has not passed any reason
Yes.
order. That's why he has moved before the second appeal. Now, second appellate authority has remanded back to with a direction to the first appellate authority. You pass a reason order.
Yes, sir.
So that's why he fixed an odd date for hearing both of you, both the parties, and order will be passed accordingly. The direction may be there. Direction may be there, specific direction may be there to provide all the information as required by. And that will help you on.
Yes, my lord.
Yes. So pending issuing notice and all, it will delay the matter rather. Because other party will come, then again we have to hear it.
No,
Judge will not be, maybe there, may not be there. If I dispose of the matter in the motion stage itself, it may help you because rasta khula hai. If you want to come,
Yes,
then you again.
He
you
can
have-
always come back to High Court, my
Yes,
lord.
it's, doesn't matter, but the matter I think that क्यों उसको why should we delay the matter in fact? Okay? Or now
okay,
you're
my lord, then kindly observation that directions.
But you will try to. We'll dispose of that in the motions. I'll pass the order.
Obliged.
Grateful, my lord.
Mama did the order.
My please, lordship, my lord, last time it was, my lord, supposed to be disposed, my lord, but we were asked to file, my lord, a small affidavit we had filed, my lord. My lord, the matter is very simple, my lord. What
Affidavit
happened?
You have already filed.
Yes, my lord.
Acha.
The matter is, my lord, the state officer issued a notice to us, my lord. I'll just nutshell, my lord, briefly. There's a road, construction of road from Jote to Poma, from Itanagar to Poma, my lord. There's a road, sanctioned road. Then they said that they want particular width of land, my lord, and issued notice to us under Public Premises Unauthorized Occupation Act. Whereas, my lord, I got allotment from land in 1997, man. When I have a government allotment, man, how it can be an unauthorized occupation? That's the simple matter, my lord. If they want to take my, because 3-story RCC building, if they want the land, my lord, they should pay compensation. That's all. And the chief state officer, but the state officer, which passed the order, my lord, impugn order is page 25. My lord, they might say why we have not gone to the appellate authority because under the unauthorized occupation, there's an appellate authority, my lord. But this order has not been passed under the Unauthorized Occupation Act, my lord, though the notice was issued under Unauthorized Occupation Act. Otherwise, my lord, the state officers should decide whether I'm illegally occupying the plot of land or not. That has to be decided by the appellate authority, state officer. In this matter, it has not decided that one, man. Now, if lordship, I'll not. Now, lordship will just turn to page 26, my lordship, yes.
Yes.
Now, lordship will allotment of land down, my lord, italics in it's written, allotment of land, my lord, first, second, third, fourth paragraph.
Hmm.
Within certain districts, roads and town lands, the right of way is to be strictly adhered to while considering land allotment to private individuals, central and state government department, NGOs, religious society, etc. for easy movement during riots, earthquake, fire, etc. No land shall be allotted without prior sanction of the government laying within 20 meters either side from central line, national highways, 15 meters either side from the center of line for a state highway, inter-district roads, 12 meters either side of central line of the village sector, colony, internal roads, unquote. The Director of Town Planning, Government of Arunachal Pradesh, Itanagar issued notice, wide notification number such and such, dated 13/3/2020, 2006, my lord. This may kindly be seen. When the notice, when this right of way is notified 13/3/2006, madam. It says such and such should be the right of way. My allotment is of 1997, madam. Notification came later on, madam. Now, this notification cannot have a retrospective effect from 1997. It will have effect from 13/3/2006 only. This is the first leg of argument, madam. The ROW won't have effect on my allotment because it was given in 1997. Now, Lordship, the Director of Town Plan, Government of Arunachal Pradesh, such and such, wherein is clear mentioned that serial number 10, road connecting National Highway 52A near Gopur Tinali to Poma via Jew Road and Lake, 24 meters ROW road width in meters. Now, this court observes that most of the affected parties need good road with a prayer to compensate for the structure that fall within ROW. It is also found that the notifications already been notified the said stretch of road by the Department of Town Planning in the year 2006, my lord, for an area of 20 meters in width. Since the road in question has already been declared as state highway and as per the APLS and RR, the width of the state highway inter-district road is 50 meters either side from the central line of road. As per the street plan as prepared by PW Division Arunachal Pradesh, they need 10 into 2 means 20 meters width, including ROW. This is the requirement of PWD. Under the circumstances as stated about this court, by seeing the urgency of the case in hand, taking leniency in the matter without taking the width of the road as per the notification number such as thus dated 13/3/2006, and under section 132, the Arunachal Pradesh Land Settlement Records Act 2012, directed the affected opposite party to remove, dismantle the structure that fall within mentioned right of way RW 10 into 20 meters within 2 weeks time from issue of this order, failing which the Office of Undersigned shall remove the same without any further notice, madam. The meantime, since I do not have any jurisdiction or payment of compensation, therefore the affected opposite party may approach the competent authority for redressal of their grievances, if any. It is also ordered that Department Power of PHED BSNL are requested to take necessary at the earliest in order to expedite the construction of widening of said sector road at the earliest. Hence, under above observation, direction, the instance case is disposed of accordingly. Now, my lord, what it says, my lord? It says the my land is within the ROW, so the building should be dismantled, madam. But this is not the work of state officer, madam. The state officer, duty of state officer is to find out whether I am illegal or unauthorized occupying a land or not, madam. That's the duty of the state officer. An order should have been passed saying that 4 or 5 notice, my lord, has already been issued, my lord. My lord, it's for the, if I'm unauthorizedly occupying a government land, my lord, the state officials should pass the eviction order, my lord, under the act. Whereas, my lord, it has not declared that I'm unauthorizedly occupying them. That's the point, my lord, simple point. If I'm not unauthorized occupying a government plot, my lord, where is the question of dismantling a building, my lord? Under what authority the state officer can pass such an order? Your Lordship, Arunachal Pradesh, my lord, the Public Premises Eviction or Unauthorized Occupants Act 2003, my lord, suppose in a volume 8, man.
Yes, volume 8.
Now, Lordship will turn to page 161. Here, my lord, my lord, subclause 7, the definition of unauthorized occupation. In relation to any public premises means occupation by any person of the public premises without authority for such occupation and includes the continuance in occupation by any person of the public premises after the authority, whether by way of grant or any other mode of transfer under which he was allowed to occupy the premises has expired or has been determined for any reason whatsoever, madam. This is the definition, madam. Whereas I have valid allotment order. So where is the unauthorized occupation, my lord? This order is totally illegal, my lord. Notice was issued under section 4, my lord. After that, it should have been determined whether I'm unauthorized occupant or not. It has not come to the conclusion that I am unauthorized occupant. What the state officer says, in 2006, there's a notification right of way has been declared in 2006. We says 24 meters. So you have to remove 24. Whereas my allotments of 1997, my lord. Right of way which has been decided in 2006 cannot have a retrospective effect. My building, my RCC building, how they will, so much of amount I have spent in constructed the RCC building, they will easily now dismantle that one, without paying any compensation to me. What I'm saying, if you want the land and building, take it, but they have to pay the compensation, man. That's the law. I'm not saying I will not give. What the state officer say, you approach the authority, my lord, for compensation because he doesn't have the power, man. How such an order can be passed? It's for the authority to decide, my lord, they will give compensation to me or not. Without paying compensation, my lord, no authority can take away my land and building. Not even the state officer. When I have the valid, my lord, allotment order. Your lordship, just to show, my lord, I have the valid allotment order. Kindly see page 16, my lord. The first annexure 1, my lord. Page 16, lordship, first annexure.
61.
16, 16, lordship.
Yes.
Policy.
Hmm.
Have been allotted on 25th April 1997. And I'm paying the revenue till date. That's all, man. This order is illegal, man, and needs to be set aside and quashed, man. That's all, man.
Yes. Yes, yes.
Yes, Lordship. Lordship, admittedly, the state officer has been issuing these orders in compliance to this notification, 2006 notification, Lordship. And in our para 8, Lordship, paragraph 8.
Paragraph 8 of your.
Yes, Lordship. By respondent number 4, Lordship. Respondent number 4. Paragraph 8, Lordship. Page 6.
Respondent number.
Page 6.
Just. Yes. Para?
8. Lordship. So what they have said here is, Lordship, the land allotted to the petitioner is, since it is purely government land, Lordship, which has been leased out for 30 years. Lordship, got it.
Yes.
Subject to the compliance of certain grounds and conditions, Lordship. Whenever the government need land for development project, Lordship, the same can be taken back if necessary with due process of law. In that case, the construction of the said road is quite significant. Various development activities project is being taken place in and around Homa Jote area. JB Law College is there, JG Lordship, Jarbon government. And then NIT has also been shifted there now, Lordship. So this road is very important road now, Lordship. But then, my learned friend has already said, Lordship, as per law, this should be taken, Lordship. Admittedly, it seems, Lordship, we have the allotment, Lordship. And all this process has been, Lordship, taken keeping this notification, 2006 notification, Lordship, wherein, Lordship, right of way has been declared 15 meters, Lordship, and his occupation comes within 15 meters, Lordship. So that's why he has been asked to, Lordship, demolish the building.
But his grievances is that the land was allotted him in 1996.
Yes,
so
yes,
2006
admitted.
certification, how it will be
Admittedly, Lordship.
the effect, and then because it has no the order of any retrospective effect. But yes, obviously there is a scheme that if it is in government is required the land, then at the time of the
Yes.
government can acquire.
Yes,
But subject to the
it's an
declaration
important
that this compensation has to be paid. for that
paid,
reason.
Lordship. I agree to that, Lordship. Proper compensation, and then Lordship, land can be taken from. This must, Lordship.
So you agreed that the authority may provide the adequate compensation to the petition.
Yes, after a verification, if he's the LOT.
So obviously verification has to be there.
Yes,
Otherwise-
yes. Lordship. Proper. After following proper procedure, Lordship. And in para 8, in the end, they have also said that, Lordship,
Para?
it is beyond, in the para 8, last para, Lordship. It is beyond the authority and jurisdiction of this deponent to consider the prayer, and there is neither any direction or order from the competent authority to consider such representation, Lordship. Representation for, Lordship. Compensation, Lordship. They have said that. Yes, admittedly, since he's a LOT, Lordship, proper LOT.
Yes, 2 and 3. Yeah, for 2 and 3.
Correspondent number 5.
5.
Yes.
Oh, you have not filed your affidavit
no
of
file.
which? Okay. Who is 2 and 3, in fact? You are 4, 2 and who is 2 and 3?
I am for,
You are for 4.
No, 3, 4, 2, 3 and 4, Lordship.
Oh, 2, 3 and 4.
Yeah.
Acha, acha.
Yes. Yes, Lordship.
Oh, 2, 3 and 4, no?
2, 3 and 4 I am.
My lord, although from the record, it seems that, my lord, the allotment order given to the petitioner was prior to the notification of 2006.
Yes.
Whereby the distance of this 15
Meter.
kilometers, 12 and all these are mentioned. But then, my lord, maybe that, my lord, the whole property of the petitioner may not be damaged during the construction of the road, my lord. So therefore,
The question is that most probably the entire building structure is there over the land, which the government is now want to acquire. That is 15 meters,
it-
suppose.
yes, it may
In that
even not
case-
touch the building also, my lord.
May not touch.
May not touch, my lord. Therefore, my lord, observing that the compensation for the building and structure should be paid, my lord, might cause difficulty to the department. My lord. My lord may say that if the building is beyond that 15 meters and it is going to be demolished for the construction of the road, then only compensation may be paid to the petitioner. My lord. If this observation may be made, then, my lord, it will be proper, my lord. Otherwise, my lord, as I have submitted, my lord, the building may not be demolished during the construction of the road. It might be standing beyond the 15 meters, my lord.
No, in that case, obviously, I feel verification will be required.
Yes, ma'am.
Then they, what will the land required for
It
the
will
road
require-
construction and whether it will anyhow the effective building or it will
Yes.
be, it has to be dismantled.
Yes.
That has to be. the
No,
verification.
my lord, we are not saying, my lord, we should be paid compensation or not. That's not the legal issues which we are raising, my lord. The legal issues is whether the state officer is competent to, my lord, pass such an order, my lord. If the government wants the land, my lord, it says that they need the government. Land acquisition process is there, my lord. The collector can issue, the state government can direct the collector to issue notification, request such and such a strip of land, and the collector will have the, my lord, estimate and give the compensation. That's the law, my lord. But where is the authority of the state officer, my lord? Section 5 says, my lord, I'm just read for you, lordship, I'll just. Section 5 says, if after considering the cause, if any shown by any person in persons or notice under section 4, and any evidence produced by him in support of same, and after personal hearing, if any given under clause B of subsection 2 of section 4, the state officer is satisfied that public premises are in unauthorized occupation, a state officer may make an order of eviction. First of all, it has to come to the conclusion that person is unauthorizedly occupying a plot of land, Malad. But that is not the, Malad, order of the state officer saying that I'm unauthorizedly occupying. So therefore, what other order can be passed? It has decided I'm not unauthorized. It ends there, Malad. You can pass any order saying that even if you're unauthorized, you have to not unauthorized, then also you have to dismantle the house. That's not for the state officer to pass an order. It's not for the state government to decide. At this stage, why is pay compensation, don't pay compensation? That question doesn't arise. But if the state wants the land, it definitely will issue notification and all. But whatever
Yes.
just and
So
proper,
he
they will
is
pay the
that point only,
compensation.
that why, under what authority the state officer
Yes, madam.
Yes.
pass the any order of.
Yes, madam. That's the saying, madam. The order is, madam, illegal, madam. That's all. Obliged.
Right. उसको भी रख देना है डिस्पोज। इसको और एक पहले डिस्पोज बटन उसको लिखा है, नोट डाउन किया है। नंबर 29 was also disposed of ना, उसको लिखा है, ये भी डिस्पोज होगा।
Small matter.
Item number 4.
Malad, for disposal. For disposal, we know this admission.
अच्छा।
Malad, before I,
Uh,
the fact in nutshell is that, my lord, let me explain. There is a
Already
place.
you have filed your affidavit in opposition.
Yes, yes.
You have already filed your affidavit in opposition or not yet
Yes.
filed? As
Lordship,
per the office note, yeah?
Pleadings are
Uh,
completed.
affidavit two has.
No,
filed
no, I
an-
don't know. As per office note is 10-6, the affidavit in opposition not yet filed on behalf of the land management has not filed. You're not going to file. Acha.
Now, my lord, the case in nutshell is that there is a place called
Hey,
Sile.
এর নামটা বা কি? Number 2. Yes, Mr. Dutt, yes.
Yeah. Well, there is a place called Sile Oyan in East Siang district of Arunachal Pradesh.
Hmm.
So what had happened is, in the earlier period, the Adi community, they have a right over land, water, and the natural resources. To establish that circle headquarter, administrative center at a particular place, they around 4.5 acres, 4.6 acres of the lands were already donated to the district administration for establishment of school, hospital, everything. My lord. So now thereafter, what had happened? That was in 2016, there was a notifications for that particular land. Now, again, what had happened? The mischief, the land department and the state government, what they have done is, you know, ex parte notification was issued to acquire the land measuring 76 acres of the land. So resulting into disembarking the right of the citizens over there. Now, on that context, my lord, what had happened? This 2019 notification, my lord, was stayed by this honorable court in another writ petition, my lord. Now, in view, again, taking shelter of that 2019 notification, the government have given a provisional land allotment to the police department, which is owned by the petitioners. Now, in view of their stay order, this 2019 notification has no force of law. And that apart, my lord, another facet of this case is that the government do not have the land. In their pleadings, in their affidavit in oppositions, they could not establish that the land donated by us belongs to the government. Number 3, my lord, the important point that I am going to urge, my lord, is that Government Land Recordment and Settlement Act and the rules framed thereunder in 2012. There is, my lord, no provision of provisional land allotment system, my lord.
Provision.
No provisional land allotment system. What they have done is they have given the provisional land allotment, my lord. So therefore, the actions, my lord, prima facie, the hindsight on the cursory submissions, my lord, have become clear that the government is trying to dispossess the land of the petitioners in a manner in violating the Article 300A of the Constitution, vis-a-vis read with Article 14 and 21 of the Constitution and the laws therein. That I'll come. Now, my lord will kindly come. I'll demonstrate with the annexures, my lord. I'll not take much time, and there is no law to be placed, my lord. My lord, this is the page 23, my lord. The annexure 1, my lord.
Yes.
This is 1st June 2016.
Hmm.
Forwarding of, my lord, the Sile Township map, my lord.
Hmm.
Circle officer, my lord, this is. Now, my lord, will kindly mark this particular thing, my lord, page 24, annexure 2. That is the land donated by us. It comes about 11 acres, my lord. Well, just if Lord will allow me to read. This deed of donation is executed on this 3rd day of June 2016 by the land owners of Sile Township area here and so in favor of government of Arunachal Pradesh represented by circle officer Sile. This circle officer is not the representative of the government. Any government, my lord, if appreciates in term of Article 166, it is to be the undersecretary. They are only the field officer. Even if the APCS or IS officers, they are posted in the field, they don't represent the government. They are just a machineries. Anyway, my lord, now we are not disputing on this, but it came to my notice. So to facilitate the second party for establishment of office, institution, etc., first party willingly, voluntarily, unconditionally and free of cost or without any compensation donates an area of 45546.8 square meters, that is 7,512 square meter for general administration, 6,314.3 square meter for government higher secondary school and government upper primary school, so and so. These are the area, then we don't dispute on this. Now, pursuant to this deed of agreement, my lord, kindly come. Here, my lord, I am at serial number 4, my lord, the petitioner, page 25, my lord.
Yes.
I am at serial number 4, yes. Now, my lord, pursuant to this gift deed, my lord, pursuant to this gift deed, my lord, this 2026, my lord, annexure 3, page 26. Now they have notified, my lord. And there is no quarrel on this, my lord. Till such period, everything was okay, going on well. Now, my lord, kindly come to page 26. This is the bone of contention, my lord. Forwarding of draft notification under section 10 of June land.
No, you are on 20,
Yes,
26.
page 28.
Oh, 20. Yes.
Page
Yes.
26, 27, we don't have any dispute.
Yes.
We have given the land. Now here they are trying to forcefully occupy our land. This is to the Director of Land Management, my lord, written by Deputy Commissioner on 27/2018. I am forwarding here with a draft notification, my lord. Need not to read, my lord. There's only a draft notification they have forwarded. Now, my lord, what had happened? Then the Director of Land Management writes back to the Deputy Commissioner. The content is at page 29, annexure 5, my lord. It says, my lord, with reference to your later number so and so, that is 20th July 2018, on the subject cited above, I am directed to request you that the proposal for issue of notification of Sile Oyan Circle under section 10 of June Land Regulations 1947 requires some clarification from your ends as to whether the said land is voluntarily donated land or it involves land compensation for acquisition of the land. Therefore, the proposal in original is returned back with request to resubmit the same along with your clarifications for taking further necessary actions, my lord. Now, what had happened, my lord? Kindly come to page 6, page 30, annexure 6. Now, my lord, this impugned thing, page 30, my lord.
Yes.
These impugned notifications, my lord, as my lord has seen in 2016, 4.6 hectares of land has already been donated. Now they are forcefully trying to acquire this land. My lord, land acquisition process, my lord knows. Nothing, no hearing, nothing was conducted and they issued ex parte order. My lord, here, whereas 73.2 acres more fully described in schedule below have been voluntarily donated by the landowners, villagers. Here we have not donated, my lord.
Yeah.
We have not donated this land. The land we have donated was in 2016, Lord has seen. So now what had happened, these particular impugned notification was put to challenge, my lord. Where is that? I can Jasmine. You can take that. And the issues one read petition was there. I read that. Notifications. Page 35 or 36. You read that. Okay, I'll come. Now, my lord, what had happened was, pursuant to this notifications, my lord, I'll come to that particular. So then what had happened when this was stayed in a another read proceedings by Lordship P.J. Saikia, and subsequently was upheld in another read petition by Justice Bajurwarma, then Justice Bajurwarma. Then the contempt petition was filed. The page 31, my lord. This particular officer, state officer, cum circle officer, my lord, in compliance of Honorable High Court Itanagar Permanent Bench Naharlagan, so and so 11 in read petition 27, all eviction notices, my lord. What had happened after issuing these notifications, they issued a eviction notice to us. But we said there is a stay order, you cannot do this, you cannot move it. When we filed the contempt notice, this particular state officer, my lord, have recalled all the eviction notice served upon to us. Yes, my lord, Annexure 8, it is there. This Annexure 7, action in issuing the Annexure 7, my lord, is pursuant to this page 32. Tamat Tako, my lord, 297, this read petitions, my lord, this is order dated 11/11/2020, my lord. Page 35, my lord. My lord, that paragraph 35, this fifth para, last para is important. Just, my lord, may I have a flip through? I'll need not to read. Because here, my lord will find the fact which Lordship Saikia has recorded here. Now, my lord, the operating portion is page 35, my lord. Therefore, the petitioners have prayed that the notifications dated 2019 being memo number so and so issued by Secretary, Land Management, Government of Arunachal Pradesh, Itanagar, and the concerned notice dated 03/11/2020 issued by State Officer cum Circle Officer CLA Circle, East Siang District, Government of Arunachal Pradesh deserves to be stayed. After considering the materials available in the records and after hearing both the sides, I am of the opinion that the petitioners are entitled to interim relief as prayed for. Accordingly, it is stayed, my lord, until further order. So this read petition is still alive, my lord. So yes, therefore, my lord, that impugned notification 2019, my lord, which they have issued, 19 September 2019, my lord, page 30, my lord. Yeah. And at page 31, the recall notice, my lord. These two actions were recalled in view of the judgment rendered. Now, my lord has seen that 2019 notification as well as that impugned notice was recalled, eviction notice was recalled. Then they again turn around and played with this Annexure 9, my lord, page 36, my lord. Provision land allowed. Well, in this case, my lord, I could have drawn a, my lord, this is a fit case for drawing suo motu contempt. Even after drawing this, you do these kind of things, not permissible, my lord. Anyway, my lord, this is a bit late. Now, my lord, these particular provisional land allotment. Now, my lord, the question, legal question that arises is whether the state government, under the relevant act and the rules, have a power to issue provisional land allotment certificate or not. The answer is no, my lord. I'll demonstrate with this
ये वाला दे दो।
volume sir.
और उसका बाद क्या करेंगे इसका बाद इसको रूल्स में है ही नहीं। हाँ ना मतलब पेज 219
219.
219 219
19.
volume
Oh.
new edition उस दिन बड़ा फोटो पास किया ना अगर मिला कर
Yes.
I'll provide it. Now, Milord, this is the Arunachal Pradesh Land Settlement Act.
Hmm.
Now, here, Milord, allotment can only be possible, Milord, in terms of definition contained at definition clause with section 2, subsection H, Milord. Kindly come to H, page 220, Milord. Subsection 2H, Milord. Now, government has a power to allow the land in the government land, Milord. Here definition says, government land means land acquired by the government under Land Acquisition Act or through donation of public for establishment of its administrative headquarters, government institutions and facilities under various wings of the government or such land as defined under section 9. Now, my lord, we'll have to see section 9. Page 225.
Yes.
Nothing, my lord, will find. Now, in view of that stay order, in view of operation of that order, so you cannot. And then, my lord, there is no government land. As the custom usages are the main source of the law, my lord. Tribal communities in Arunachal, they have customary right over the land, water, and the natural resources. Now, in your definition class section 2, subsection H, it says the government land, unless or otherwise you have acquired through the Land Acquisition Act or by means of donations, you cannot issue this piece of paper. This piece of paper remains as a piece of paper. It will have no force of law. You cannot arbitrarily issue any land allotment in my private land. So the allotment given to the police department is prima facie illegal. Now, my lord, kindly come to annexure 10, page 38. How they have done it, very unfortunate. This is how the additional deputy commissioner writes, you pay the challan and all. Even this page 39 is by the deputy, by the district, for the deputy commissioner, my lord, writing to the police department to pay the premium, my lord. Now, my lord, very interesting, my lord. To fortify my argument, my lord, kindly come to page 40, paragraph, annexure 11, my lord. We have sought for the documents from the DRO's office. Kindly come, my lord, in the box, my lord. Furnish one, Roman 1, my lord. Furnish the deed of donations, copy made in between the Lahore Singh Pao, father of Sri Basan Singh Pao, and the government of Arunachal. My lord, the answer is no. Not available. If that is not available, from where you have drawn the power to issue this provisional land certificate? I'm sorry, my lord, this action something. 2, my lord, Roman 2, furnish the notification order for opening of C-class post. They have furnished it, my lord. They have furnished it, there is no quarrel. But the land has not been donated by us, that particular person. Challan we have asked. Now, my lord, Again, we further submitted an RTI applications to the circle officer. Page 41, Lord, annexure 12. We have sought the details record. Then, my lord, page 42, the reply comes from the circle officer, 6 September. The answer is, my lord, while inviting reference to your RTI applications, number Neil dated 17/8/2022, it is to inform you that the records which you sought for are not available in the office of the office. That means, my lord, there was no agreement, nothing. Now thereafter, to confirm whether there is no record at all maintained by the circle officer at Sile Oyan, then we again resorted by filing RTI to the Deputy Commissioner Office, Siang, my lord, only to confirm, my lord. Kindly see page 43, my lord. Here, my lord, the information we sought for was there really any process adopted by the government to allow the land? The answer is page 44, my lord. Box serial number 1, my lord. Is there any land acquisition process by the government of Arunachal Pradesh before allotment of land to the police department, Sile Oyan police station? The answer is, my lord, not available. That means there was no acquisition process at all. That is the flagrant violation of 1894 Land Acquisition Act, read with Lara 2013, my lord. Unless or until, if you don't follow the due process of law, you cannot make a citizen dispossess the land and try to obtain. In that even, my lord, what happens? Immediately Article 14 and mandate of Article 300A is violated. So therefore, the action of the government is not sustainable in the eyes of law. My lord, we'll see that we have made this series of representations. Still then the government has not acted on this. This 45 to 48, my lord, are my representations. Now, my lord, page 49 and 50, on the strength of that particular provisional land allotment order, they have given to us, my lord, this notice, because they were forcefully occupying. But then this has been recalled, my lord. Last time I got the instructions from my client that they have recalled it. Now, my lord, has seen last time that my lord, sorry, I'll furnish this in one of the matter which I was dealing, Tagam Mibang versus so and so, where, my lord, the issue was relating to the provisional land allotment, whether the government has a power or not. So here, my lord, my contention. Here are 12. Now, my lord, the government in paragraph, the additional AG, my lord, I'll provide this copy. Mr. Para 12, Mr. N. Ratan, learned additional advocate general appearing for the state of for the state respondent, submits that the additional deputy commissioner Ramgong never had any objection without any valid reasons. In fact, the objection for issuance of NOC to the petitioner is based on the verification report that so and so submitted by so and so, which clearly reflect. No, this is not a paragraph. 13. Well, I'll provide this. But the subject matter, I remember, I dealt with, I lost that case. I'm relying my own lost case. There, it was clearly held that government do not have the power under the Land Acquisition Act and the 2000 Rules 12. They do not have the power to issue any provisional land allotment, except for the regular process. So therefore, my lord, the affidavit in opposition which they have filed, this has no substance, no relevance. They should have, the government affidavit should have been very categorical on a question of law, whether the notification 19 September 2019, which they have issued, it was against the government land. That definition they have failed to provide in their affidavit. The contention that, my lord, I have raised, the government affidavit has no response. Simply matter of records here and there, my lord, they said foundation stone, this. Anyone can lay foundation stone. Can that be a basis to disown my property? No, you cannot do this. So therefore, my lord, whatever, even the police department, the government statement, these are verbatim, my lord. Page 16, my lord, affidavit by the respondent number 3, my lord.
Hmm.
15, my lord, 15 to 16, one particular point, my lord, page 15 to 16.
Yeah.
My lord, the same deed of agreement which was interfered. This is, we are not disputing it, that we have donated 4.6 acres of the land. They are trying to fortify that 2019 notification, land acquisition notification was on the basis of this particular. This cannot be the ground. Therefore, my lord, prima facie, there is no reasons as to sustain with their contention that they have a power to issue temporary provisional land allotment certificate under the Act. And if the government can substantiate their argument by showing that they have a power under the 2000 Land Settlement Record Act and rule frame thereunder in 2012, then, my lord, I will concede my argument, yes, under section 14 of the General Clause Act, my lord, power to excise from time to time. Yes, within the bound of law, if the Act permits that you have the power. Now, my lord, even General Clause Act, section 21, my lord, it will say power to rescind, alter, amend. So therefore, this, you have the power under this General Clause Act also, my lord. I will not dispute on this. Now, the question is, my lord, a specific question to be asked to the government is that whether do you have the power to issue provisional land allotment or not? If it is not, this impugned order has to be interfered with. Gratefully.
Lordship. This, we have categorically stated that this is a donated land, Lordship. And earlier, was donated way back in 1951-52, Lordship. At that point of time, in every districts, all the lands were donated land only, Lordship. And then, Lordship, I question the Lordship, this very petitioner's locus, Lordship. If Lordship comes to, we have stated also in our affidavit by respondent number 3, Lordship. Lordship, page 15. Lordship may come to deed of donation, Lordship. This deed of donation, Lordship. This deed, 3rd day of June 2016 by landowner of Sile Township area herein after call the First Party, Lordship. And First Party, Lordship, if you see, Lordship, here in down below, First Party. 1, 2, 3, 4, 5, 6. And Lordship, again 1, 2. They are the witnesses, Lordship. In the witness, the petitioner's name is there. It's not the landowner, Lordship. And we have said so in our statement also, Lordship. In paragraph, Lordship. They have not said anything about this, Lordship. Para, Lordship, 4, my paragraph 4, Lordship. Lordship. Here, Lordship. Further, the deed of donation of land for Sile Oyan Township at around so and so square meter was, Lordship, found it,
Page para?
para 4, page 3,
Yes.
page 3,
Hmm.
second para. Was donated free of cost by the villagers and owners of the, where the plaintiff himself signed as one of the witness in the deed of donation on 3/6/2016. Lordship. He's not mother. That's why, Lordship, he's being termed as encroacher, Lordship. That's why he have encroached the land. That's why he have been given notice, Lordship. And he have represented himself also in our Lordship. I saw. Just a second. And Lordship, landowner, regarding landowner, Lordship. Again, in 2017, the landowner's family, Lordship, come to page 13, Lordship, and etc. These landowners, the real landowners, they have said this much only, Lordship. With due respect and humble submission, with the offspring of late so and so, ex-HGB, the landowner of police station Sile Oyan, wish to apprise you the following facts for your kind consideration and so and so. These are the place where the present police station Sile Oyan area was voluntarily donated by less so and so for the cause of people of Sile Oyan Circle during the year 2002. Further, this is to inform you that lots of welfare activities like they wanted, Lordship, the issue of landowner certificate and commendation certificate in the name of late Lahore Singh, Lordship, landowner. Construction of befitting monuments of fixation of signboard mentioning the name of the landowner at the said place. This much only they have, Lordship, and the signature is here, Lordship. And Lordship, another document to show that the petitioner is not the landowner, Lordship. He represented himself before the Lordship authority, asking him to allot land, Lordship, some land. So, Lordship, they have replied that since it's a donated land, they cannot allot this Lordship land to him, Lordship. Where is the page? Documents are here. Lordship, just a minute. That representation is also here, Lordship. I marked it, I can't find it. Lordship, para 18. Our reply is here, Lordship. Page 18, Lordship. Page 18. Lordship got it. This is Lordship. To Bason Singh Oyan village, subject notice representation of unauthorized occupant of government land as Sile outpost, Lordship. Received your representation on 7 January 2013 instance. In this regard, I am to inform you that there is no private land within map of township area. The land is already donated by the land of by the Oyan people to the government since 1951-52. Here he was replied, Lordship. Just because he has not been allotted land, he is not a donor at all, Lordship. I have shown already, Lordship. And then, Lordship, since this is under the government's occupation, Lordship, this whole area is, Lordship. Lordship, for the interest of the public only, the land has been LPC has been issued to the police, lordship, police department, lordship. And then, lordship, in my affidavit in opposition filed by respondent number 2, lordship. Respondent number 2, lordship. R2, lordship. Earlier one was respondent number 3, and this is 2, lordship.
Yes.
2, lordship. 2, page 4, lordship. Para 5. Here we have said, lordship. The answering respondent begs to state that the provisional land allotment order number so and so dated land measuring so and so supposedly allotted to APP. A proposal for regular allotment was sent to the Director Land Management Goptok AP on 19/3/2013 by dealer SO, lordship. The regular one has been sent already. It takes time. That's why, lordship, LPC has been provisional has been issued, lordship. That's all, lordship. Because he's not a donor, lordship. He doesn't have any locus, lordship. He was just a witness. How he can say that he is a donor, lordship? And regarding the lordship notification and all, lordship, my learned friend will.
My lord, I have not much to submit, my lord. My lord, in the state of Arunachal Pradesh, how the land become governmental, my lord? It is either by donation or by acquisition. Earlier, in entire district, my lord, even till today, my lord, the entire district of the Arunachal Pradesh district headquarters are donated by the public of that areas, my lord. Even take the instance of Itanagar, my lord, Itanagar and Nahalagarh, my lord. Even the capital cities, the land of the capital cities, my lord, it has been donated by the people of this area, my lord. It was never acquired. So therefore, my lord, you can see all these donations were made when the headquarters of this Arunachal Pradesh was there in Shillong, my lord. Because of that, my lord, the documents, my lord, all the records could not be, my lord, preserved safely, my lord. This is for these headquarters, my lord. Likewise, my lord, this land, my lord, particular land, my lord, where the petitioner is claiming the land to be there, my lord. They have clearly submitted that this land was donated by the people of that area, Sile area, my lord. Lord has seen the document, my lord. And in that document, my lord, petitioner is not the landowner. My lord has seen, his number comes in number 6, my lord, in the witness. There are only 6 landowners, my lord. My lord has seen that. In the first party, it is 6, and the second party is the CO, who is represented the deputy commissioner, my lord. Now, my friend has rightly submitted that the petitioner has no locus to file this even writ petition, my lord. On that count, this writ petition can be dismissed, my lord. And I do pray for that also, my lord. And yes, regarding the issuance of this notification, my lord has seen when the land donation agreement was made, a recommendation was sent to the state, my lord, that is Secretary and Director of Land Management, my lord. Accordingly, we have issued the earlier notification, my lord. That there was again a recommendation, based on which we have issued the second notification, my lord. My lord, if the petitioner, he himself is admitting that there was a land donation deed, my lord, wherein he was one of the witness, my lord. How can he say now, my lord, that land was never donated? Firstly. Secondly, where is his locus, my lord? He was just merely a witness to that donation deed, my lord. So therefore, if at all the action of the authorities is to be challenged, my lord. It has to be by appropriate person, my lord, whose right has been infringed, my lord. Here, my lord, can see no right of the petitioner has been infringed. He was just a mere witness, my lord. Therefore, my prayer would be that, my lord, this writ petition is devoid of merit and the petitioner has no locus.
My lord, my brother is smiling.
So therefore, my prayer would be that, my lord, this petition is not maintainable in this form, my lord. For want of appropriate person to know this honorable court, my lord. That much, my lord.
My lord, I have 2 minutes rejoinder. Kindly have my paragraph 21, page 16 of my read petition. अभी हम जो लिखा हुआ है इसमें I will just.
Yes.
The basic question before Lordship for determination of this case was whether the government has a power to issue provisional land allotment or not. The government council could not make any argument and could not rebut my argument. That is what it is there. That it is most respectfully begs to submit that neither the petitioner number 1 nor his late father had donated impugned provisional plot of land with allotment in favor of the State Police Department, which is merely seen from the RTI reply of the respondent authorities. The impugned provisional land allotment order is falling under the preliminary notification law, which is under a state. Notification dated 9/9/2019, which is a state, sorry, this stands a state by this honorable court, and in the garb of impugned provisional land of the SP so and so. The question is, my lord, the land department ought to have come with a clarification with their power, whether they have a power to issue provisional land allotment or not, my lord. 1. And number 2, my lord, the present land is not under, that's why when I try to raise that, that I have shown their page 15 and 16 of their affidavit, they said, this is something different. The land, my lord, now I'll put certain questions, my lord. Page 15 and 16 of the affidavit in opposition.
Now they are
By-
raising the point
by
that the
R3.
provisional certificate is okay, but you are raising the law points where the
Yes,
the authority. But
and
the
this was-
question is that as per them,
Yes.
you are not at all the landowner.
Yes, well, therefore, this particular page 15 and 16 of the R3, affidavit in opposition and R3. The pursuant to this, the notification dated 2016 was issued, my lord. 16, right?
Yeah.
My lord will just mark it, my lord. Kindly that pursuant to this deed of agreement, my lord. Notification number 12/12/2016, dated 12/12/2016 was issued. And it does not describe anything about the police department. Schools and other things, my lord. It is reflected, my lord will see that while passing the order. And in paragraph 21 of my read petition, my lord, I have made a categorical statement. Except for, my lord, this police station where it is, we are not quarreling on that. They are encroaching my land. Otherwise, why you should have issued me an eviction notice? That is my locus. Making a statement without substantiating with the records, you cannot say that my read petition has, I have no locus to assail them. Now, my lord, second question to them is, in terms of that 2000 notifications, how much land has been donated? You have not placed it. Trying to try to confuse with the page 15 and 16 of the affidavit in opposition filed by the R3, which has a relevancy with the 2012/2016 notifications. End of the chapter, my lord. Now, where is the final notification showing In 2000, this you have the land, we have donated the land, you have not donated. Well, whatever may be the reasons, my lord, the basic question for interfering in this particular repetition is whether the state government has the power for issuing provisional land allotment or not. The answer is no, my lord. My lord, that's why, my lord, I have taken, my lord, to section 2, subclause H, the definition of the government land, and section 9 of the 2000 Act, my lord, where it says unless by means of donations or by acquiring through the process of 2013 or 1894, you have not initiated. Even the record from our side demonstrates, my lord, no acquisition process was initiated. So therefore, these impugn provisional land allotment given to the police department, my lord, will specifically make also observation also. The petitioner is not quarreling with that present police checkpost and the police station where it was established. Because they are encroaching my land beyond that land, my lord. And even in 2016 also, my lord, in the land agreement, my lord, there was nothing, no whisper was made about donation to the land with regards to donation of land to the police department or police station. My lord, I'll provide that particular judgment at a point of time. Grateful, my lord. Go ahead. Yes, my lord is passing the waters. My brother was laughing while he was making submission. When my brother laughs, my lord, that is end of the matter and teaching of the guilt.
Is it Mr. Kamlu?
Yes.
Laugh.
No, my lord,
He was not very fair today, trying to defend the illegal actions.
petitioner, my lord, as I have submitted earlier also. Firstly, he do not have the locus, my lord. And to claim that, my lord, the land belongs to him, my lord. He
Oh,
should-
Yes.
He should also produce some document saying that the land actually belongs to him, my lord. I have gone through the writ petition. There is nothing as such, no document is annexed here in the writ petition to establish his right in that very land, my lord.
Yes.
That's why we are saying he's totally an encroacher of this donated land. Lordship, I am for
Are 2 and 3.
2, 3 and 4, 2 and 3, Lordship.
2, 3 and
2 and 3.
Four.
My friend is for 1 and 4.
I am for 1 and 4. my lord.
1 and 4.
Yes.
Will be reserved.
Yes.
Okay, make it reserved. And take the names of all these things, and particularly for one, for woman, for women's kingdom. We have the book in Bangladesh also. We can update from Bangladesh. You can take the record. Okay, I'll wait for the, but just now you give the this one.
My lord, this is a bill pending matter, admitted bill pending matter.
Pardon?
Bill amounting to 42 lakhs for road maintenance and repairing. My lord, here, first, the annexure A of the petitions is a recommendation for LOC demand for the contractor payment on the month of September 2000 in respect of EPWD qualification. So this was,
Can it be listed another day, because we have 2 matters at 2 also. And one VC from Guwahati. So if I fix another date, will it be inconvenient for you?
another week,
Pardon?
going back,
When?
when you like to stay.
No,
Next question, Margaret.
can it be fixed on next week?
Next week, all right.
Today, actually, I have a VC, one hearing matter at 2. Another matter is at also at 2. So that's why I'm saying that if it can be taken up in other day.
Next week.
Next, tomorrow, will it?
Tomorrow may not be possible. Tomorrow, Thursday, already lots of hearing matters have already been fixed. Friday, we are not in a position to take. In fact, next week, will it be inconvenient for you if we fix in next week?
My lord, okay.
Next week?
According to your
Okay, then.
convenience.
It's my personal inconvenience. In fact,
Yes,
today other 2 matters are also there.
Okay.
Monday, lots of 17 is, 17 can be fixed, or there are lots of matters.
Tuesday.
Huh? Can it be fixed? Then they sakega Monday ko. Because it will be fixed on Monday. Otherwise, case is ready, we may dispose of also. And 2-3 matters I have already disposed, we have to pass the dictation also. So let us be on Monday.
Oh, like, on Monday.
Okay, list on Monday. Monday is 17th, huh? Monday is 17th. Item number? Yes, item number 11. Petitioner who is representing. Mr. H.K. Jammu was there, I think, na?
Yes, Your Lordship.
You are for item number 8? Oh, sorry, 11?
Lordship, we need some more time to get instruction. We have already
For respond number, whom?
respondent number Union of India.
Oh, Union, acha. 1. Union is 1 or what?
Your Lordship, 4 and 5.
Union is 4 and 5.
Four, five, six, 7.
Four, 5. No, you're referring for 4, 5, 6, and 7.
Yes, Lordship.
4 and 5, 6, and 7 degrees appearing. Union of India. You are appearing as in the strength of DSGI.
Yes, Lordship.
Huh?
I'm appearing on behalf of DSGI.
On behalf of DSGI, that's it. On behalf of DSGI, appear person. 4, 5, 6, and 7.
Yes, Lordship.
And one is by you.
No, my lord.
Oh, sorry. One is by you, land management.
Yes, ma'am.
Mr. Kamduk is for 1. And you are for 2.
2 and 3.
2 and 3. Mr. Iredam is for 2 and 3, non-government advocate. Who needs time? You need time.
Yes, Lordship.
How many weeks?
3 weeks, Lordship.
Huh?
3 weeks.
The Learned Council appearing on behalf of Mr. DSGI for respond number 4 to 7. Paid some more time to file their affidavit in opposition. A hard petitioner said to Namli Kitipa. Prayer allowed. List accordingly. After 3 weeks, you need?
Yes, sir.
After 3. And what about you? You have filed already? Yes. List accordingly after 3 weeks. Okay, we're listing it after 3 weeks. 3 weeks, enabling the respondent number 4 to 7 to file their affidavit in opposition.
Much obliged.
Hello.
Your Lordship, I'm appearing on behalf of Nalopada. We need some more time to file a rejoinder.
To file?
A rejoinder.
Rejoinder. Here also RD department is there?
No, NIPCO. I'm for a NIPCO.
Achha. So NIPCO is.
7, 8, 9.
7, 8, 9.
Yes.
Standing council may be checked for phone number 7, 8, and 9. One is by you. 1. One, no, 1, 5. 1, 5, 6. No. Acha, take it 7, 8, 9. No? 5, 1, 5, 6. You have for 1, 5, 6. 1, 5, and 6. Num.
I am for 4, my lord. Yes, ma'am. Mr. L. Parme will be there, ma'am. Yes, ma'am. Standing council.
Yes. Only yes.
I'm not smart. Maybe, I guess.
3 weeks.
Pardon? 3 weeks. 3 weeks for it. Enabling the petitioner side to file their affidavit in written. List accordingly. Okay. After.
Always.
My lord, my lord, I appear for respondent NHPC in this case. We have filed our counter affidavit today.
Counter affidavit. Today it's.
Yes, today we have already filed it.
Okay. Have you received the
No, your.
today only you have filed it?
They will, it has been filed, they will get the copy.
Okay. I will deeply receive.
Lordship, we also need some time. We have received the instruction just few days back, Lordship.
In any case, they may like to file the joint affidavit, whatever it is.
For
The joint
this-
or.
No, Lordship, we are filing affidavit.
Okay, my lord is there. 4 weeks, 6 weeks will not make no difference to me. Any date, my lord,
4
please.
weeks after 4 weeks.
So you are for NHPC.
Yes, yes.
That is respondent number 5.
4 and 5.
4 and 5.
Let it be after vacation because in
You
July, I
understand?
think we are already having vacation.
For I on behalf of HK Jamo.
On behalf of
HK Jamo. Heli. Kato Jamo.
Petitioner.
My lord, my
Petitioner.
presence may be recorded for NHPC. My presence for
yes,
NHPC.
yes, obviously. You're Mr. Saxena, no?
Yes, no, I'm Mr. Saxena. He
You're
is leading
Mr.
senior.
Yes,
He's
he-
leading the case for NSPC. He is the senior counsel.
yes, senior counsel, I know.
Assisted by K. Saxena.
Come to PSL. What's his name what was his name? Hey, I'm done. Now done. You are assisted by, you are assisting.
I am assisting Mr.
Okay.
P.T. Tiwari.
Heard Mr. Yo so and so, appearing on behalf of HK Jammu for the petitioner. Full stop, and also heard Mr. So and so, the senior counsel, assisted by Mr. K. Saxena for respondent number 4 and 5. And it is submitted that they have already filed their affidavit in opposition today itself. However, Mr. M.S. G. The government advocate appearing on behalf of 3 and 4, 2 and 3.
No, 3 only.
3 submitted that they need some more time to file their affidavit in opposition as they have received, you have already received the instructions, they have already received the instructions. And they need some more time to prepare their affidavit in opposition. Land management, you have already filed or
No,
no?
my lord. I have the same prayer,
Same prayer. Same prayer for the land management, that is for number 1. So sorry, 2. And 1 is represented by? You already represented 1 and 2. 1 and 2. List the matter accordingly after vacation, Mr.
Yes.
It will be list after vacation.
Obliged.
Most obliged. May I please, madam? Madam, I am appearing for the respondent, madam. Madam, I need some time to file affidavit in reply, madam. Yes, madam.
No, Your Lordship. I'm appearing for 1, 2, and 3, Your Lordship.
I am appearing for private residence.
3 weeks, madam. Yes.
Yes, Your Lordship.
Obliged.
Yes, Your Lordship.
My lord, connected matters, my lord. It is pending before the apex court, my lord. On the basis of which, my lord, they are claiming this solution on the basis of a judgment rendered by a division bench, my lord, of this honorable court. That judgment is put to challenge in the SLP, my lord. So my prayer would be that, my lord, let that matter be decided by the apex court first. I might have, my lord. In some of the cases, I have already submitted. If not in this case, my lord, there is so many, my lord, analogous matter, my lord. In some of the matters, my lord, I have made this submission, my lord. And accordingly, my lord, SL connected matter, my lord, I will have to work out, my lord. Not right now, my lord, it is not possible, my lord. There are, my lord, lot of connected matter, my lord. More than 40 50 matters is pending before this honorable court, my lord. Yes, my lord. The order passed by the division bench is put to challenge in the SLP, my lord. And he has annexed the order passed by this division bench of this honorable court, my lord.
Which has
Yeah,
been put to challenge.
yes, he is claiming the solution, my lord, on the basis of the order, judgment and order passed by division bench of this honorable court, my lord. That order is again put to challenge in the SLP, my lord, which is pending before this Supreme Court, my lord. So therefore, my submission is that, my lord, let that SLP be decided first by the apex court. If they are entitled, my lord, if honorable Supreme Court says that they are really entitled, then they will, my lord. No, my lord, the government, my lord. Yes, my lord. So that will decide the fate of all these analogous matter, my lord. Ah.
Yes, my lord.
Yes, Your Lordship. Yes, Lordship. Yes, Your Lordship.
Petitioner is aware of the pendency of the SLP, my lord. Yes.
Much obliged.
May I please, madam? Well, in this in contempt petition, whatever it was a year ago, but till that they have not
Lordship,
filed.
Lordship, today we have filed Wakalatnama. Earlier Wakalatnamas was misplaced somewhere. So because of that reason, I have, on the last occasion also, my name was also not shown in the cause list. So I was not aware. So therefore, Your Lordship, time may be given. In the meantime, I will file. Yes, Your Lordship. Yes, Your Lordship. I will take entire instruction. Because the order is, yes, Commissioner, only sole respondent. So a fixed date may be given for the.
Kedapi.
Yes, Your Lordship, I'll file my affidavit as well as I will take instruction if the matter has already been. Let the matter come up on 22. July. 22 July, after vacation. Okay. Lordship, let it be fixed on 22 July. I have informed.
Yeah.
Yes, that is after immediately after vacation.
Obliged.
Much obliged.
May I plead, Your Lordship? Madam, Your Lordship, the matter was listed last on 25 or 21/5/2024. Your Honorable Court was pleased to direct, Your Lordship may see that order. 21/5/2024. May I read second paragraph, page 3. May I read page 3? May I read second, third paragraph? We take note of the fact that petitioner alleged that husband died on such instance by unidentified bomb purportedly left behind by the army personnel after field firing for which such case number under section 174 safety registration on several occasions prayer made by the learned DSGI CGC time was granted to the government of India respondent 1, 5 and 6 to file their counter affidavit contrary in opposition in the matter. one last opportunity of 3 weeks is granted to the respondent number 1, 5, and 6 to file their affidavit in opposition the matter. It is made clear that if such affidavit is not filed within the time allowed, the court would invoke the doctrine of non-traverse, and it would be presumed that the Union of India, through the Defense Secretary, Ministry of Defense, Government of India, respondent number 1, commanding officer at 82 Mountain Brigade, respondent number 5, and the general officer commanding Chief Eastern Command, respondent number 6, have admitted the claim of the petitioner. The learned counsel appearing on the DSGI is directed to send a download copy. So this copy was given to them. And they were supposed to file a reply by last chance was given, Your Lordship. But then till today, we have not got reply.
We have received the instruction and already affidavit has to be filed. Already we have received the documents. So suppose we have filed today itself, but there's some issues, we have to make correction.
Yes.
Actually, we have submitted our affidavit on filing section, but due to some miscommunication, we could not be filed by on this day. Already we have submitted our affidavit, and we have already filed our affidavit. Already we have submitted the affidavit, but they have not filed till yet. Due to some technical, some correction to be made. Yes, we have prepared all the affidavit in opposition. Prepared, yes, no, sir. We have submitted to the filing section, and no, in our filing section, yes. And we have taken it back due to some correction has to be made. Otherwise, Lordship, in Monday we will file our affidavit. Till Monday, last opportunity may be given. Otherwise, all the affidavit has been prepared. Yes. We don't need it back. By tomorrow. And matter may be listed on Monday.
To accept this case of members. And we have provided copies of the counter affidavit and one application for removal of respondent number 5 and 6, which are the commanders and Army Commander of Eastern Command. However, the DSGI, Mr. Mato Kato, has not filed it today, and that is the reason why I'm also again coming here. We have a receipt which is signed by Mr. Mato Kato on 4th of June, and again on 9th of June by his subordinate Mr. Togo Kato. And today itself, I get to know that they are out of station and still not filed. This is the our situation. It has already been duly vetted by the higher formation and provided to the government.
We have filed, we've already filed.
Government said they have filed.
I'm for respondent number 2, 3, 4, 7, 8, and 9. 7, 8, and 9.
1,
Yes,
5, and 6.
1, 5,
Yes.
1, 5, 6.
Yes, more.
M Tanga yun. Tanga.
Captain Karthik. Captain. AG legal, AG legal, 181.
Monday, Monday. By tomorrow. Hello.
Oblige. Sorry? Okay, oblige.
Please, your lordship. No, me and the May it please your lordship.
Ah,
I am
yes.
appearing for the petitioners.
Yes.
Here, respondents are yet to file the affidavit.
Yes, you know.
No,
My lord, I am
Four, five.
My lord,
Here, respondent number 4 have filed their affidavit, that is Deputy Commissioner. Respondent number 4.
Or-
4.
I'm
Rest,
No, Lordship, 4 and 5, I'm Lordship.
rest they have not yet to file their affidavit.
my lord, I am appearing for respondent number 2 and 3, my lord. But I will not be filing affidavit, my lord, in this case.
Yes.
4 or 5. So, of course. Lordship.
I am for 2 and 3, my lord. I will not be filing affidavit, my lord.
They have not yet appeared. Yes, sir.
Their main.
No, service already completed, your lordship. Completed. I've already earlier taken steps. It's written copy. One is your lordship, the state
One is Lordship, yes, yes, one.
Six and seven, your lordship, there is a standing council over here. We have already served them the copy. Yes, sir.
Good.
Yes, yes, yes. After 2 or 3 weeks, no problem, your lordship. Problem. Yes, your lordship. Obliged.
Uh, Your lordship, this is also a solemn matter. This is also a solemn matter. Similar to the last that we.
Yes, my lord. Same order may be passed, my lord. Yes, ma'am. कितना था पहले?
16 and 17.
16, 17.
Much obliged.
Hearing matters,
I am in fact from 24 to 28. All hearing matter. Different cases, man. I would have preferred, my lord, RFA, the last item, my lord. But my lord, if it is inconvenient, my lord, we can, yes. We can do it on some other day, my lord. After a week or 2 weeks. As far as 25, 26, 27 and concerned, my lord, I need to take instructions. I have just learned that one of them has passed away, my lord. So I will, these are connected matters, 25, 26 and 27. Yes, my lord. The person in item number 27, it appears, my lord. Likha Khope, I think. I will take instructions, my lord. If they want to pursue or not, the family members. Yes. Man. 18, man. My lord, this is an appeal against acquittal, my lord. I was thinking of doing item number 28 actually. So yes, so 24 I could not prepare very well. So this may also be, my lord, taken up after a week or 2 weeks, my lord. 28. So no, 24, my lord. 24. I was prepared with this, my lord. Yes. If it is inconvenient, my lord, we can do it on some other day, my lord. Otherwise, this is a civil, yes, this is a civil matter. It will take some time, my lord. My lord. In that case, my lord, some other day, my lord. That's what, my lord, because today is Wednesday, my lord, and Friday, your lordship will be. I will make a prayer for, my lord. Yes, I will make a prayer for adjournment, my lord, for both of us. Joint prayer. It's a very peculiar case, in fact. My lord, way back in 2004, 5, my lord,
when the judiciary was not properly separated. Very peculiar things have happened. So it will take some time to take your lordship to the documents. Yes, yeah. No plaint was also filed. It's a very peculiar case. Two weeks, man. Let me 2 weeks. Obliged.
A possible matter, and on default bill, he was released. Then thereafter, what happened? The intimation was given to the disciplinary authority and I should be allowed to function. So then what the legal parts into and in terms of 6 years, we can use 6 and 7. Then within 90 days, the suspension order has to be reviewed. So in my case, now, he cease to operate. This suspension order. What cease to operate from 8 to 2024. So then that alleged operate doesn't not counts. Remember last time the instructions was called for whether only to ascertain the fact whether my suspension was reviewed or not. So it's taking also for us to see whether.
Yes.
My lord, in the last second FERA.
Last?
Second FERA. However, inadvertently, his suspension order could not be reviewed within the period. This review, and we cannot take inquiry regarding this matter. He was released on,
As he was in.
yes, he was in custody for from September 25 September 2023 to February 2024.
February 2024.
February. And one inquiry was constituted in month of April 2024, and inquiry report was already submitted. Inquiry report was already submitted.
Before whom?
Before the authorities. Now order has to be passed, whether penalty has to be done or not.
Order?
Authority has to pass an order, whether minor or major penalty has to be imposed or not against this.
No.
Now it has to be decided by the authority.
Let me say, regular trial, maybe if a criminal case is to institute, and on the same set of facts, with the department inquiry are conducted, has to be still final. Anyway, the subject matter, but here they said, I
that he has. Even if suppose he was in.
After he,
I cannot be very sensitive matter with the POXO cases related.
yes.
That is there. It's obviously, but what the law says, in fact, he was released on most probably on default bail. But
Even I appeared in the law court also. I moved the bail application. Then the court refused to grant the default bail. Then I say that in the form of leave. I have next.
yes, yes. Review petition was there.
Yes. They going there. Please continue.
Oh, this case when the special judge was. I have passed the order.
That means this is past case in this batch. Probably this must be reported.
So he was most probably because the default bail order could not be passed by the special judge because he was on leave or something. That problem was there.
Yes. But then that force comes into the terms of giving.
Mhm.
But this, while when I was going through the report in the law, might be behind the law.
Why?
In this particular case.
Acha? Why? For what reason?
No, it's daughter. The daughter, Dr. Maurice, evidently timing for the area also. What Dr. Maurice working with children, I'm children, and later come to came to know that there are some person behind the school. There is what I don't think if when I was doing master in political science and Dr. Modi was doing this master in commerce. But in terms of the Jesuit
Okay, I need something. Okay, I'll pass the order.
yeah.
I'll pass the order, then again rise by 3:45. By another VC is there.
There's claim going on.
Acha, acha.
After this, I have matter again.
From principal said.
Then, yes. Report number
Oh, yes, report number 2. Probably having the Justice Pathak will be there. With division bench matter, in fact, I am also there. So it is a review matter, so it will be yes, from 17th, Justice Pathak is coming.